Hi, everybody. Welcome to this week's Big Hurdle. I'm kdee, President of Osage Advisors. And today we're talking about something that catches a lot of business owners completely off guard. Even after they successfully close the sale of their company, you sign the documents, you've shaken hands, you think you're done, and then 69 days later, the buyer comes back with a different number than you agreed to at closing. This is called the post-closing true-up. And it can be one of the most financially painful experiences, emotionally frustrating moments in the entire sales process. Let's talk about what it is, where it comes from, and most importantly, how to protect yourself before it happens. What is the post-closing true-up? At closing, the purchase price is based on a set of agreed-upon financial assumptions. And most importantly, the level of working capital being delivered with the business. Working capital is currently basically assets minus liabilities, essentially the financial fuel left in the tank to run the business day to day. Buyer and the seller agree in advance on a target number. In the trade, we call it the peg. If the actual working capital at closing is above the peg, the seller gets more money. If it's below the peg, the buyer gets paid the difference. That typically settles in 60 to 90 days after closing once the books are finalized. Remember, when you do the working capital, the buyer's accountant typically is doing the calculation and they're incentivized to, get the best deal for their client. So as a seller, you need to be prepared. So you don't end up in the wrong side of this. It's very important. So the working capital adjustment. Let's start with the most common source of true-up disputes for working capital. Here's 4 areas where the numbers most often come apart. Accounts receivable aging. The buyer's team reviews every receivable and argues that anything past a certain age, 90, 120 days, is uncollectible and then shouldn't count towards the working capital. It's a common thing. For example, an owner has always carried a loyal customer, say 90 days plus because of the relationship. That receivable gets written down or entirely excluded in the buyer's accountant, and the seller never saw this coming. And so you have to explain that and get them to buy into it. Number 2 is really a really big one is inventory valuation. This is very common in manufacturing, distribution, and retail deals. The buyer's team walks the warehouse and determines that a portion of the inventory is slow moving, obsolete, or simply not usable, and argues it shouldn't count towards the working capital at full value. For example, think about it. You carry $2 million inventory on the books. The buyer's team identifies $400,000 of product that hasn't moved in, say, a year or more and flags it as obsolete. That's $400,000 comes straight out of the working capital calculation to your detriment and directly reduces what you walk away with. A third area you need to be concerned about is accrued liabilities that maybe weren't captured properly at closing. They could be things like accrued vacation time, unpaid bonuses, warranty reserves, a customer deposit that weren't properly reflected on the closing balance sheet. The buyer finds them and adds them to the liability, further reducing working capital. For example, say you have a company with 40 employees, have never formally accrued unused vacation. The buyer's team calculates $180,000 of accrued PTO and then reduces working capital from the closing balance sheet, which is a negative on you. A fourth area that comes into play is your revenue recognition policy. If a seller recognizes revenue on a particular project or a contract that buyer argues wasn't fully earned or closed properly, they typically will reverse that out of the working capital and potentially reduce the purchase price. Here's a key takeaway, right? You got to protect yourself. Working capital disputes are the number one source of post-closing conflicts. The PEG should be negotiated very carefully and documented precisely. Ambiguity always benefits the buyer. We spend a lot of time in this area. People say, well, why are we talking about working capital? Because just everything I just talked about, it's incredibly important to make sure it's properly documented and defined. Another area that I just want to put a word in about is the earnouts. Hey, if your deal includes an earnout, just really pay close attention once the buyer owns the business. They control how revenue and EBITDA are calculated post-closing, management fees, overhead allocations, integrated costs, go on and on and on, right? We always spend a major amount of effort in this area with our clients that it is very precisely documented. Vague language in the purchase agreement is very expensive to you. As I just said, make sure that we specifically identify the performance measurement and how the expenses are allocated against it. This is a big area. You know, another area on this true up calculation is the indemnification clauses, right? This one typically will surprise owners the most because it comes, could come 12, 18 months after closing, well after you thought everything was done, right? You've gone through this whole area. You've gone through the purchase price. You sold the business. You've gone through the true up. You come through the true up. Everything looks good. You feel like you're free and clear. Well, indemnification could trigger additional claims against you. You made certain representations and warranties about the business at closing. If the buyer comes through and discovers that some of these were inaccurate or even unintentional, which is most likely the case, they could cause damage during this survivor period, which is 12, 18 months. What are some examples you need to think about? Say you had a customer contract that had a change of control clause, seller didn't disclose, customer exits post-closing because they don't like the new buyer. You have a tax liability that surfaces during an IRS exam or state exam. There's liability there potentially. Even though you've done environmental, there's an environmental issue that emerges that the seller represent didn't exist. Maybe your environmental firm missed it. That could cause additional hardship to you and cost you money. One of the most common is like an employee claim that happened pre-closing, discrimination, wage dispute, wrongful termination. These things will could surface afterwards and well down the road. Rep and warranty insurance is a tool that you can use to help mitigate some of this potential exposure and risk to you and kind of shift that to the insurance company. I mean, now there's a cost of rep and warranty insurance, but depending on your deal size, it's really worth looking into those policies and discuss them with your advisors early in the process. Now, how do you protect yourself? Negotiating the right guardrails is critical to the deal. So engaging the right M&A attorney who has deep experience in M&A is really important to you because they're going to negotiate all these items in the purchase agreement, the stock purchase agreement, to minimize potential for exposure on your part. And here are a couple tools sophisticated sellers use to level the playing field, so to speak. You can use a working capital collar. We always tried it. Instead of having a static number of like X, you have a range, right? So if it's 5% less, 5% more, there's no change. There's a band around the target. So there's a little flexibility. So if the actual working capital falls within that range, there's no adjustment. This is a common tool that we employ and negotiate with potential buyers. So if the adjustment only triggers this number, if there's adjustment if you're outside the band, right? So for example, if we set the peg at say 4 million and the collar plus or minus 200,000 and the closing balance sheet shows $3.8 million, there's no adjustment. Only if it falls below 3.8 million does the buyer have a claim. And only for the excess below the floor, not the full difference in the peg. They will try to negotiate the full peg, by the way. So be careful. So watch out for that. Without a collar, any variance could trigger a true up. A collar eliminates the noise, the focus, the cost about this, material mechanism that we use in determining the working capital peg and collar. Another tool you could use, we call an indemnification basket. That's like small amounts. So dispute for $1,000 here, $4,000 here, $5,000. That means that buyer cannot make a claim against you. So they kind of like this basket fills up to say a specific level. And only when it gets to a level, all these claims together, does that tip and they can now have accumulated claim against you. So this saves you a lot of time and energy and money and legal fees And so once, if it crosses the threshold, then you have a discussion with the buyer and a negotiation on what makes sense for a settlement. Let me give you an example, right? Say you set the basket at $150,000. The buyer finds $40,000 in tax, $60,000 in vendor disputes. Neither trigger a claim. Combined, they're only $100,000. You don't cross the threshold. And when the claim until the claim exceeds $150,000, does the seller own anything? And by the way, this is only during the indemnification period. So after, say, 18 months or 2 years, what you agree to, it goes away. You know, in a tipping basket, once the threshold is crossed, the buyer recovers dollar for dollar the full amount, not just the excess. It's a true deductible. They only recover the amount above the basket. Again, by the way, you have the ability. They can't just take the money out of your escrow. They have to make a claim against your escrow. You have the right to dispute their claim and settle with them. We always push for a true deductible structure. The indemnification cap ceiling on the total seller liability, that's always a negotiated item. The buyer's going to shoot for the highest amount. You're going to shoot for the lowest amount of exposure. Just as the basket protects from bottom, the cap protects you from total exposure on the top. So typically negotiated a percentage of the purchase price. Typically maybe 10%, 15%, 20%. The cap means the buyer cannot combat you for more than the agreed upon amount of this indemnification. So say you had a $10 million deal with a 10% cap, the seller's maximum exposure is $1 million. Without a cap, the seller's liability theoretically is unlimited for the duration of the survival period, which is not where you want to be. Dispute resolution, the mechanisms, who decides when you can't agree. For example, the purchase price typically will have a clear process for resolving true-up disputes. And if you'll bring in an independent neutral accountant, CPA from they've previously agreed to in advance on both sides, who determines is binding, right? Their determination is binding. Without this, only path is litigation, which is expensive for both parties. For example, a buyer and a seller disagree on $300,000 of inventory valuation. Rather than going to court, they submit the dispute to a pre-agreed neutral CPA accountant. The decision is binding. The process takes 60 days. Both sides avoid six-figure legal fees, and then they settle, right? If your agreement doesn't specify a dispute resolution mechanism, you are one disagreement away from a lawsuit. This should be a non-negotiable in every purchase. That's why a good, strong legal team is so important. So what is key takeaway we're trying to get at today for you guys is the best protection is a well-negotiated purchase agreement before signing. Built-in dispute resolution mechanisms are not extras. They are the tools every seller's attorney should be fighting for at the table. By the way, we're fighting with you because we see this out of 25 years of business at Osage. We bring these up. We have conversations internally as a team, you as the client, us as your advisor, and attorneys to come up with solutions that work for you to get the right deal. So the big picture here, here's the bottom line, right? The post-closing true-up is not the buyer trying to renegotiate your deal. It is a contractual process, and it will happen. It's in every deal. The question is whether you negotiate the right guardrails on the front end to protect yourself when it does. A business owner who spent 30 years, 40 years building their company deserves to walk away from a closing table with the number they agreed to, not a number that gets eroded 90 days later by a process they didn't fully understand going in. This is exactly why having experienced advisors, investment bankers like us, and legal, it's not a cost. It's an investment in the outcome. So really, I think it's important to understand the true up and really talk to your lawyer. Make sure your lawyer is a good, strong M&A attorney who's done multiple deals over a long period and has a team behind him. Because negotiating these items inside the purchase agreement is going to cause or going to relieve you of a lot of stress when we get to the true up period. I hope you find this beneficial. Again, my name is Keith D, President of Osage Advisors. Thank you for being with us today for this week's Big Hurdle. If you enjoyed this session, please feel free to subscribe to our podcast, The Ins and Outs of Selling a Business, and have a great day.